Hi, and thanks for joining me for another video. For those of you who don't know, my name is Peter Lamont, and for the past 20 years, I've been an attorney in New Jersey, helping people with business, litigation, real estate, bankruptcy, and contract matters. In today's video, I want to talk about something that is very important if you find yourself either being sued or needing to sue someone. And we're going to be talking about building a timeline to assist your attorney, or if you're representing yourself as a pro se litigant, to help yourself. So let's start with what a timeline is, and then we're going to talk about why it's important, what should be in your timeline, and then I'm going to give you some examples of what a timeline could look like. So what is a timeline? A timeline really is a detailed chronology of the events that have led you to the point where you're now either on the precipice of litigation, or you've been sued, or you're ready to sue somebody else. It is the story, and it's very important because let's say you call an attorney and you give them the rundown of what your claim is about. You're not going to, in that initial consultation, remember everything. Dates, details, names, places. You're going to be providing them with a general overview so that they can have an understanding of what the claim is and how they're going to either move forward with that if you're the plaintiff or defend it if you're the defendant. A timeline is a specific, detailed, organized chronology of the events. If, let's say, you're in a partnership dispute, your timeline might start from the first discussions that you had with your partners about forming a company. It might talk about negotiations or drafting the partnership or operating agreement. It might move down the line into problems that have occurred, issues that might be generating animosity between the partners, and then as it starts to crescendo, because as you move closer to litigation, there's always a buildup in hostility and agitation and disputes between people. So you would then focus in on the details of that. Yesterday he did this, the day before he did that, that sort of thing. So that's what a timeline is. Now, why is a timeline important? And why do I say it's one of the most important things in litigation? It's so important because it serves so many functions. Number one, it gives your attorney the ability to have a much deeper understanding of what the claim is about. By providing details and specifics, it gives the attorney the ability to formulate a plan, whether it's on the plaintiff's end or if you're being sued on the defense side. The next thing it does is it helps the attorney spot and highlight holes in your case. And this is important because in the preliminary planning stages of a lawsuit, you want that attorney to be thinking about what the other side is going to be doing. People often refer to litigation as a chess match, and in some instances and in some ways it is. You need to be thinking ahead of your adversary or opponent. So having a timeline where maybe the attorney can spot a hole in your case or an issue with evidence or something that doesn't match up or help you in your case, letting them see it and knowing and being able to address it early on is going to be beneficial to you throughout the case. So it gives attorneys an overview, where a lot of detail and understanding. It gives them the ability to look for holes, but it also gives you the ability to remember things that you probably forgot when you went through your initial overview of the case. Sitting down and putting a chronology, whether it's in standard chronological order or reverse chronological order, whatever is more convenient for you, helps jog your memory. You're going to start remembering things that maybe you had overlooked. And some of those things might be very important. And if you hadn't sat down and gone through the process of creating a timeline, you might not have remembered those specific details until much later. And, in some cases, maybe too late. And the last reason that it's important to have a timeline is because in some instances, the information that's contained in your timeline can be extrapolated and used at trial as a visual aid to help assist a jury and a judge in understanding your claim. Now, that said, understand that when you give your timeline to your attorney, it is attorney-client privileged. It is not something that your attorney is going to disclose to the other side or send to the court. It's between you and your attorney, and it's used as an internal document to help you and your attorney prepare your case. But when I talk about extrapolating information, sometimes your timeline might be useful because, especially in criminal matters, establishing where you were at certain times of the day or night can be useful, and that can be pulled out and put into a visual aid that you can show a jury at trial, and it has a heavier impact on them when they can see the timeline in front of them. Now, the timeline is critical for attorneys for the reasons that I stated, but there's one other reason that I feel a timeline is useful, and that's because depending upon the specifics that you put in your timeline, the detail that you put into it, it can actually save you money. Here's how. So if an attorney is going to draft a complaint or have to draft an answer and a counterclaim if you're being sued, they have to get all the facts down, they have to put them in the pleading, in the complaint or answer, and they have to be right. So what I have experienced over the course of my practice is that when I have a client that gives me a detailed timeline, it's very easy to take a lot of that information and just move it over to the pleading, to the complaint, or to the answer. And then when I send it to them to review, everything's there. When you contrast that with the type of client that just gives generalities and does not give you a timeline, what often happens is you put the facts in the complaint the way that you believe them to be, and then when you send them to the client to review, they start talking about specifics and changes, and it ultimately increases the attorney's fees because there are more modifications that have to be made than if they had provided you with a timeline giving you the facts. So that's just an added bonus, I think, to having a timeline ready for your attorney. And I think that it will ultimately save you a little bit in the way of attorney's fees. All right, moving on. What should be in your timeline? So there are certain things that should always be in your timeline. Dates, names, specifics concerning a particular meeting, issue, allegation, conflict, contract, specifics about those matters. You should also include potential witness names. So if you know that someone's aware of a discussion, you should include in your timeline, John Smith was present at this meeting. Another thing you should be doing, you should be referencing any relevant evidence that you might have, any documentary, video, photographic evidence that you might have, and reference that in your timeline. So for example, you might say, on October 11th, 2022, we signed a contract. Contract is attached, or contract is an exhibit, or I just identify it. Contracts in my file, so that the attorney knows that there is a corresponding document to go with that timeline entry. And that's important because it's going to help the attorney organize the evidence and the documents, because ultimately, during the process of discovery, some of that information is going to have to be disclosed to the other side. And it's really beneficial to kind of have that at an early stage in the case. The other thing that you should have in there is any comments or concerns that you might not think is highly relevant to the factual overview of the case, but it might be. For example, I had a client recently say to me in a breach of contract case, I just want to make you aware of the fact that the contract was not signed by the other side. Now, I'm glad they told me. Was it relevant to the case? No. The reason being that even though that party hadn't signed the contract, they performed under the contract, so the lack of signature really wasn't relevant. But I was happy to see the client giving me information that they weren't sure was relevant or not important, but they ask. And it's better to ask. It's better to put your comments or questions in your timeline. Is it important that this didn't happen? Or, I just want to make a note that the contract was unsigned. That's very helpful. So, like I said, sometimes you might think something is relevant or important, and at the end of the day, the attorney doesn't agree with you, doesn't think it's important, but that doesn't mean that you shouldn't share it with them, because sometimes it is helpful. Okay, so now you know what a timeline is, why it's important, and what you should put in that timeline. How should you write the timeline? Really, the answer is simple. It's up to you. Whatever is better for you. You can go the old-fashioned route with pen and paper and write down by hand a list of your entries. You can use a word processor like Microsoft Word or Google Docs and type it out there. Or if you're really tech savvy, there are some apps and platforms available online that can help you generate a timeline. You can search them on the App Store, whether it's Google or Apple, they're there. There's even some new AI, artificial intelligence platforms that'll help you generate a timeline based on your entries. So it doesn't matter how you do it. The most important thing is that the information that you have on the timeline is able to be transferred or shared with your attorney. So I've seen some apps that allow you to build a timeline, but then there's no way to transfer that data or share that data. And I've seen people taking screenshots, and now you've got like 32 screenshots. Not good. You want something that you can share, that you can either convert to an image or a PDF or a document. But at the end of the day, it's personal preference. What is going to be easiest for you to generate a timeline with these specifics in there? Are you a digital person? Are you a pen and paper person? Are you somewhere in between? That's up to you. Look, I fluctuate. I'm pretty big into technology. I like seeing, the developments and changes and how artificial intelligence is going to impact our world. But at the same time, sometimes I'll print out a document because I like to read it, have it in my hands and read it. So personal preference, it doesn't make a difference. All right, now I'm going to give you an example of what a timeline could look like. I'm going to put it up on the screen in a second. And we'll just go through it very, very briefly, just so that you have an understanding. So in this case, being a breach of contract case, you'll see here that the entries are dated. Some dates are specific because the person actually knows the date. Other dates are general. You'll see, for example, May 2022. They don't have the specific day, but they are giving you a time frame. And you'll see as you go throughout the timeline that it is kind of building up to, like I said, that crescendo where now you can see how intense this dispute is becoming, and then ultimately where it all falls apart, leading to the litigation. So this is something I'll put a link in the notes. You can always download it just to give you an idea of what it looks like. Obviously, this is all fictitious, but it just gives you an idea of what a timeline could look like. All right, well, let's wrap this up. I think that now you have an understanding of what a timeline is, why it's important, what should be in it, and how you should generate it. And I think that if you take the time on the front end of your lawsuit, again, whether you're being sued or suing, and put your timeline down on paper or digital paper, if you will, you're going to see that it's going to help your attorney prepare your case better. It's going to save you a little bit of money in attorney's fees, and hopefully will help you generate a much better outcome than without it. One of the benefits that I can tell you is critical through a timeline is that by putting down the specifics, jogging your memory, it oftentimes helps avoid surprises. Look, you might like being surprised with a birthday party, or surprised when you find a brand new car out in front of your house. But nobody in their right mind wants to be surprised at a trial or a deposition. That's one of the worst things that can happen to an attorney. When you think you know the facts because your client has given them to you, but they left out a critical key issue. And then you get to a deposition or you get to trial, and now you're surprised, and it changes the entire structure of your case. So that timeline will help eliminate those unwanted surprises, because it allows you to jog your memory, get it all down on paper, and then it allows your attorney to help prepare your case. One final note, I know we've been talking about giving it to your attorney. In certain instances, maybe you're going to represent yourself. That's called pro se representation. You should still do the timeline, because the timeline is still important, still relevant, and you will still benefit from it, very similar to if you had an attorney and you gave it to him or her. All right, well, hopefully that is this information is helpful. Please, if you haven't subscribed to the channel, do so, and like this video because it helps. Let me know what kind of content you want to see. Also, don't forget to click the notification bell so that you're notified when new videos come out. And if you have any questions or comments, just please leave a comment, and I'll try to get to all your questions. If you have any topics or legal issues that you want addressed in future videos, also let me know in the comments below. All right, thank you. I'll talk to you soon.